Linda, take it away.
I think you should go I think this is the last chance you'll have to visit the early republic. So we've traveled together from 1783 to 1821, which is today, through 7 trials. I don't know if Nancy Myrsiades is here. Yes. Where is she? Oh, there she is. Hi, Don. Good, I'm glad you brought Don. I wanted to, first of all, thank Don Cresswell and Nancy Myrsiades for gifting me with this very helpful primary resource of maps of early America, which was incredibly useful, so thank you so much. One of these is going in my book, so I'll have to ask for your permission. That's why I'm thanking you. We'll be touching to base today with a direct connection to another Folkways resident, and I don't think Arvin Sharpless is here today, but one of the primary documents that I resurrected from the Pennsylvania Historical Society goes back in his family tree to Blakey Sharpless in 1825, and I'll be explaining that as part of the Quaker abolition movement as it relates to this case. So today we're dealing with the John Reed trials from 1821. He was a fugitive slave, and the title "No Proof of Manumission" refers to the fact that he was a self-emancipated slave. Emancipating by verbal agreement was one route. Of course, there's no paper trail for that, so those slaves wound up being recaptured and renditioned or reclaimed back to the South. Separately, even if you have a paper trail, the prospect of debt on the estate meant you could be reclaimed. So emancipation, whether you bought your way out or it was agreed to orally, or even if it was approved on a deathbed, were all subject to your being re-enslaved. So self-emancipation became a practice of preference for many fugitives. They simply claimed they were free men by getting themselves to a free state where the presumption was, if you were black, that you were a free person. That would be in Vermont, Massachusetts, and Pennsylvania. Whereas in any slave state, the legal presumption was that any black was a slave and had to prove that he or she was free. This crime of John Reed, John Reed claimed to have been emancipated 3 times and to have lived in freedom twice. First emancipation was 10 years when he lived with his grandfather. His claim was that he was re-enslaved, and that thereafter, when he moved to Pennsylvania, he became freed once more. None of those claims had a paper trail behind it. As it will turn out in this case, a paper trail for his status as a slave in the state of Maryland, which would be the claim made by the Griffith family on behalf of the slave owner, Samuel Griffith, who was killed by John Reed in an attempt by a slave posse that he commanded to abscond with him from Kennett Square near Westchester, Pennsylvania, in Chester County, back to Maryland. He was shot and killed in that event. And so his family, on his behalf, in an attempt to reclaim Reed, also had no paper trail. They had never registered him as a slave in the legal records of Maryland, and so that reclamation effort failed subsequent to the slave posse's attempt to abscond with him. In 1820 in Pennsylvania, I'm going to go through in a minute the laws as they lay out, but in 1820 in Pennsylvania there was an Anti-Kidnapping Act put into place, and it was that Anti-Kidnapping Act under which John Reed was tried. He, in effect, was the defendant, but the trial turned out to be operated in such a way by a Republican judge who was anti-slavery.
Great, thank you.
Who, now I lost my train of thought. It was operated in such a way that the state anti-kidnapping law came into play, and the presumption within the trial was that he was in fact the plaintiff rather than the defendant, even though it was charged for murder, and I'll show you how some of that worked out. Okay, so the crime took place in Pennsylvania in December of 1820, and there was a conflict between federal law and state law over whether it was a kidnapping or a reclamation of a fugitive. The trials themselves were informed by the work of abolitionists who pursued court cases and legislation to ensure that federal provisions of the Fugitive Slave Clause of 1793 would not obtain in the case of John Reed. And as the final trial in this series, his ordeal will take its place among the cases of Northern resistance to slave additions that made equality the watchword for legal and extra-legal efforts to save the soul of America. Keep in mind that slavery, as Lincoln said, was considered the original sin of the new nation, and insofar it was going to be or was not going to be addressed, it would affect the collective identity of this presumed land of the free. So states' rights as against federal law will be the primary conflict, legal conflict in this case. Southern slavery codes were embedded in state laws. Northern liberty laws were embedded in the northern states, so they were in direct conflict with one another. So what is the prevailing law that would control here? Well, in Article 4 of the Constitution, there is the Fugitive Slave Clause, which says that, that free states must abide by the laws of the slave states in terms of property and state law. So the failure of state law to accommodate a southern state became the centerpiece of the trials under which John Reed would have to defend himself. He was subjected to 2 trials because he killed one member of the slave posse named Shipley, and he killed Griffith, the slave owner himself. The actual event itself occurred in the dead of night when they broke into his house where he was living with his wife and child. He had been living in Pennsylvania in Kennett Square for 3 years. He was accepted as a free man there. He had no problems with his neighbors. He took odd jobs, and that's how he provided for himself. He warned them as they tried to break through the door that he would shoot who would ever come through, so he gave them warning. He also proposed that he would meet with them on the morrow in order to discuss their claim. They, conceded to neither of those, and by force and by violence tried to seize and take him out of the state. Seizure, removal from the state, doing so without a certificate under the 1793 Fugitive Act, which was the federal law, and not having provided for a certificate of removal under the state law, 1820 Anti-Kidnapping Act, made them liable to a charge of 3 separate felonies. So there was a question raised, even as you're trying Reed, whether it was he, in fact, who should have been the defendant and not them. In the first trial, there was enough sympathy in the jury for the argument that he was, in fact, the victim rather than the perpetrator, that he was acquitted. In the second trial, he was convicted, but not of the charge, not of the crime for which he was charged, which was murder in the first degree, but of manslaughter, because the Pennsylvanians themselves felt some sympathy for him and mitigation for the crime as a potential kidnap victim. So we're going to get these divergent renderings under the law, one for the Griffin trial, one for the Shipley trial, same facts and evidence. And I will try to explain the differential between the two, why it happened, and that will get us into the politics of the case and the law of the case. Okay, so let me go to the first 3 slides, just to give you a feel for, first slide. This is a slide from 1840 and appeared in the American Anti-Slavery Almanac. Here to your left, the figure with the hat in white represents the slave state who is trying to manacle the slave. And onto your right, in the black costume, is a representative of a free state who is trying to take the chains off of a fugitive. We can go to the next one, which is from 1846, and this is from the Washington, Pennsylvania Patriot, appeared in that newspaper. Presumably this fugitive has been trapped or caught or at least stymied by what looks like a slave posse dog. So we can move on to the next one, and this one is more germane to this case. It actually is a piece of the popular press that came out relative to John Reed himself. The poem was written by Walter Grayson about him. The title of this popular print piece is "Nigger Jack the Slave." So they gave him this informal name. One paragraph or one stanza reads, "Poor Nigger Jack went to prison for freedom he had fought, served 15 years at labor for the lesson he had taught," and so on. So it reprises the crime, his sentence, and then the moral that should be drawn from it. You can take that down for the time being and just put up the next one. I'll introduce it, and then I won't come back to it. Okay, this is the document written by William Kirk in 1825 that was a letter written to Blakey Sharpless asking for instructions on how to foil slave masters and slave posses, and then how to engage in collecting evidence for trial on behalf of the fugitive slave. It's a very interesting letter, and we'll go over it in a little bit of detail later, but I just wanted to show you what it looks like. You can pull that down, and we'll pull up the last slide at the end. Okay. All right, so what is the legal picture here? We're going to ask 4 questions for this talk. And they are going to be, what were the controlling and conflicting laws? The second question, how did abolitionists defend fugitive slaves? Then we're going to ask, what were the politics behind the case? And then we're going to ask number 4, why did the 2 verdicts differ? And then finally, number 5, I'll give you my summary thoughts on the series as a whole, answering the questions about democracy that were initially the rationale for delivering the series. So with regard to the law, in terms of the law in Pennsylvania, from 1705 to 1780, Negroes, in quotes, black citizens of the state, or inhabitants of the state, were subjected to a separate system of what were called Negro trials. That's how they're referred to in the documents. TRYALS. So that's actually the legal term for the system of law under which they were adjudicated. Free and black slaves during that century, 1705 to 1780, or that time period, 75-year period, received only summary justice, which meant that they had to face a panel of 6 landowners and a judge without counsel, without the ability to answer questions, without the ability to question their accusers, and under a separate set of black statutes or codes with separate and more severe penalties than those faced by other inhabitants of the state, presuming that they were white, because Indians had their own trials. That was in place for 75 years. In 1780 was the Gradual Abolition Act that we talked about last time, whereby slaves born after 1780 would remain slaves for 28 years, but slaves born before 1780 were slaves for life. By the time of our trial in 1821, it would take some 45 to 67 years to get everybody who was enslaved in the state of Pennsylvania emancipated. It would take that long, but by the time we get to our trial, it was pretty much the presumption that if you were black, you were in Pennsylvania a free man, whether you were a fugitive, self-emancipated, or otherwise. Well, for 7 years, that was the law in Pennsylvania. Slaves were presumed to be free men. They were guaranteed the same rights to be adjudged, corrected, and punished as all other inhabitants of the state. The only exception was that slaves, people who were registered as slaves, if you weren't registered by any omission by your owner, you were automatically freed in a court. But if you were registered as a slave during this time period, the only qualification was you could not testify against free men. Otherwise, you had the same rights: right to a trial, right to habeas corpus, right to self-defense, etc. Well, this obtained for 7 years in Pennsylvania. Then we had the revolution in 1783, and essentially, the law was up for grabs until 1783, the end of the revolution. By 1787, and the U.S. Constitution came in, and the Fugitive Slave Clause came into play. So we had a new federal government, and under the Fugitive Slave Clause, which was implemented in 1793 through legislation to enforce it in the Fugitive Slave Act, blacks were presumed to be slaves under the Constitution. Now that's a reversal of Pennsylvania law, so that all the rights to which they had become, or were beginning to become accustomed, would be eliminated, and the summary justice would be reinstalled for them. So this was a great shock to the state. It required that all states respect the laws of other states, which meant that slave laws now applied to free states like Pennsylvania. And the slave owner had merely to produce a certificate from a slave state, which he could take into a free state, or had to produce only his oral testimony to the effect that a black in a free state was his slave, and upon that could remove him from the state with no other legal maneuvers necessary. Well, it was easy to get these certificates from the slave states because all slave states presumed that all blacks were slaves. Any appeals of seizures made in Pennsylvania had to be conducted in the slave state of origin. So as you can see, it was pretty much a done deal. Well, for 30 years, this is what Pennsylvania has to live under, and then by 1820, the contradictions of between a free state and slave states and states against federal government led Pennsylvania to adopt in 1820 the Anti-Kidnapping Act, which was passed just months before Reed's trial. So Reed's trial will be one of the first tests of that act. And it penalizes any who should seize or take by violence and abscond out of the state, carry away any Negro or mulatto from the Commonwealth of Pennsylvania. So a slave owner coming in without a proper certificate from his state under federal law, and failing to get from a judge or court of record in Pennsylvania a certificate of removal. He now has to have two certificates, one state, one federal, under two different laws, and seizes and takes away, and by force, and without the certificates, that's where you get your felonies, right, will suffer $500 fine and 7 years of hard labor. That makes the slave owner not the victim, but the perpetrator, right? So this was a major change, and this is what will be tried in the trials, the two trials of John Reed. Okay, now I'm going to talk about we're up to number 2. How did the abolitionists defend fugitive slaves? And we'll talk about the William Kirk letter to Blakey Sharpless. Abolitionists and Quaker sympathizers used the conflict between state and federal law to stalemate renditions. Renditions are reclamations, where you return the slave. And they created an army of abolitionist sympathizers who they trained to intervene in slave renditions. You could see from the letter that Kirk wrote, I won't flip through it all, but you saw the handwriting. It's barely legible. I mean, for me to read that manuscript page and translate it was something I wish on nobody who's mentally sane. In any case, these were simple people who were dedicated to an ideal. Their goal was to intervene in these court cases. They interviewed possible deponents for depositions. They visited courthouses to discover legal papers. They went into the South to find witnesses on behalf of the fugitives. They helped to identify, which is very difficult, to identify a fugitive slave and or whether or not they were truly kidnapped blacks. And they served habeas writs to force the state to produce the party, the slave. Their whole idea was to make certain that the requisitions of the law were strictly fulfilled. In this letter, Sharpless was being asked to provide instructions to Kirk on the circumstances under which a master could seize a slave, the master's right to enter a house, whether any other party in the house could have the same right to prosecute a slave owner as the owner of the house would have, whether the slave had a right of self-defense against unknown persons entering his house, and whether he could have that same right if they entered in disguise or surprise as opposed to if they identified themselves. How must the master make proof, and by whom must it be attested, and so forth. So these are actually in that letter, these particular, you can see the detail to which simple people went in order to assume this role of the army of abolitionists. There are other provisions under case law that would be appropriate here in order to interfere with this trial. I'll only mention two of them because the others have to do with the Gradual Abolition Act, and they have to do with your status as whether you're born before 1780 or after. But two of them are really worth our noting. One is that case law, people who would defend the fugitive slaves would file their names as freemen, and that would give Pennsylvania courts the cover to give them a trial by jury. So that was determined by case law, and it was retained, and it gave them full legal rights at trial. In 1817, Commonwealth v. Holloway gave an additional tool to the abolitionists insofar as fugitives could avoid seizure where they could be avoiding punishment, I know this is a lot of negatives, by the state of Pennsylvania for a crime in that state. In other words, if you could presume that the black who was the defendant had committed some crime in Pennsylvania, Pennsylvania, according to its case law after 1817, had the right to say, you may not take that fugitive, they must pay for that crime in Pennsylvania first. So they would charge them with minor crimes in order to get them a trial by jury, and that would prevent the abduction or the reclamation, and then you buy time and you play it out and they have to pay for the sentence and so on. But what it did was it added years in jail to the defendant, but it was a way of their avoiding being re-enslaved. Okay, the politics behind the case. Rather than going through the witness's testimony, etc., I decided to introduce this case in a slightly different way because the documents were fairly interesting. So we just did the one document that I found interesting, gave you an idea of how the abolitionists approached supporting the fugitive slave in court. Now I want to look at the politics behind the players in the case. In this instance, the two judges. So since there were two trials, they wound up being two judges. The first judge was Judge John Ross, who was a Republican, and he had been an advocate, an anti-slavery advocate since 1797, when he tried as a litigant, he tried on behalf of Abarilla Blackmore, a landmark case called Respublica v. Blackmore, and he successfully argued a position that freed Blackmore and would inform the John Reed case. They made him judge for the first trial. It shows you there's a little positive presumption here on behalf of Reed. In that case, he argued the following: a slave's freedom is heaven's best gift. Essential justice makes no color distinction, but if a distinction must necessarily be set up, it ought infallibly to be in favor of liberty. Well, that's a pretty strong statement. And then separately, in the appeal to that case, which he also won, he says, we have a constitution which declares all men free. If another law declares free men slaves, why do you boast of a constitution? And that would be a line of argument that would be used in Reed. That is that if you have a provision in the Constitution in 1787 that requires, that allows for slave owners to reclaim their slaves, if that is in violation with another part of the Constitution in 1791, 4 years after the Constitution was ratified, the Bill of Rights was ratified. And that gave men, all men, the rights to trial by jury and gave them rights to habeas, etc. So that would be in conflict with the Fugitive Slave Clause within the same document now. So that would be argued, that in fact you have rights under the Constitution that are being violated by Article 4 of the same Constitution. And the Bill of Rights would favor, of course, John Reed. Well, Judge Ross did something else interesting. He served in the Pennsylvania House, and he served as a U.S. congressman during a period of almost 20 years after the Blackmore case in 1797. Then he is appointed as the president judge of 4 counties, among them the county in which Reed will be tried, and then he becomes the judge for that trial. He, while he is now president judge of those counties in 1818, has a case which he decides in Norristown. And in that case, he rules that masters who seize their slaves and take them out of the state without going before a judge are guilty of felony. And he says here what they're guilty of: bypassing the law, acting by force, breaking the peace, and provoking a violent event. Now, there's now going to be this positive predisposition on the part of the presiding judge on behalf of Reed 3 years later when he is tried. Well, in the second trial, the second judge, Isaac Darlington, is going to make clear that he disagrees with Ross's ruling in Norristown, and that slave owners are not guilty of a felony. Now, this is interesting. I'm going to give you Darlington's history, and you're going to see why it's interesting. Darlington, in the first trial, he's not judge yet. Judge Ross is the judge. And in that trial, Darlington is appointed to try the case as a deputy attorney general. Interesting. So he's got this now position. I mean, if he's ambitious, he's just been appointed. He wants to win this case as prosecutor. He loses the case. He is subsequently assigned to try Shipley, because we've lost the Griffith case, right? So he tries the second one, member of the slave posse. And he is made a presiding judge for the court in Chester County, which will try this case, under which president judge, the president judge of the 4 counties, is the first judge. All right, so there's a little politics going on here now. You'd think he'd be sympathetic to John Reed, right? On the other hand, he was the prosecutor in the first trial, which he lost, and his ego is hurt. He wants a do-over, and he's going to get the do-over, and he's going to get it as judge. So we're going to examine how that affects the trial when we go through the chart later. But this is the problem with Darlington. Now, Darlington is a Federalist. he is not a Republican, right? The Federalists are in support of federal law. So we'll find in the second trial that federal law is going to become the dominant discussion, right? They're going to talk about Reed in terms of his not being a free man, a plaintiff, a victim. They're going to talk about him being a murderer, property of another man, and a fugitive under another body of law, federal law, which should, according to the Constitution, the federal Constitution, should preempt state law. All right, but his boss is going to be Ross. Darlington is a Quaker. All right, so he's politically ambitious, he's a Federalist, and he's a Quaker, and he's just lost the prior conviction. So that's what he comes into the picture with, and he will now be of interest to us through another document that I exhumed from the Pennsylvania Historical Society, whereby he wrote a letter to a colleague 10 days before Ross was indicted for the first trial. All right, he's not tried yet, but Darlington has been assigned as the prosecuting attorney, deputy attorney general. Before the indictment, he meets in his office. He's telling this now in the letter to his friend. He meets in his office with Edward Griffith, who is the brother of the deceased victim, the slave owner who was killed by Reed. And in this visit, Griffith makes clear, as Darlington is recounting in his letter, that he wishes to retain the Attorney General's services. The Attorney General is prosecuting for the state. The plaintiff wants to retain the Attorney General separately on his behalf, right, to prosecute the case. Well, we had talked previously about private prosecution. If you recollect, states did not have public prosecutors until well into the 19th century. Some of them, on important cases, will assign a public prosecutor, as was done in this case, even though the state in general didn't. But for crimes that involved murders, they often did. Well, in any other situation, had a murder not occurred in this reclamation, the Griffith family might in fact have privately prosecuted to get Reed reclaimed. But the state decided, because it was a murder, to take the case. So he goes, Griffith's brother goes to the prosecutor and wishes to retain him in his service. The Attorney General doesn't find anything unusual about this because, as he says, he appears to be very much a gentleman. And his instinct is that let the facts, this is now Darlington referring to Griffith, the instincts of the brother of the deceased is such that all he wishes to do is to have the facts go before the tribunals of justice. So I won't object to it. He didn't object to taking the retainer. I don't know that he in fact took it, but the way he describes it in the letter suggests that he had no problem. He didn't think there was any conflict with his taking it. Nor was there any conflict raised to recuse him as judge in the second trial because he was prosecutor in the first. It all went through smoothly. But when the defense counsel, who was a Quaker in the first trial, what later became county prosecutor for Chester County for the second trial, they forced him to recuse because he might be too sympathetic to Reed. There's another piece of politics that are of some interest here. One other piece of information about Darlington's letter. Griffith proposes as well, no, he doesn't propose. Darlington had engaged a Mr. Dower, D-U-E-R, to marshal the evidence, so he's going to use him as his investigator. And Griffith reveals to him in that meeting that he too had retained Doer, and this again was a revelation that didn't appear to unsettle the Attorney General. So we've got now the plaintiff and the prosecutor working hand in glove. They're going to lose this case in any case, but this is the politics behind it. All right. So now we get to the point where I'd like to, I'll give you an idea of what happened. The first jury acquits of murder in the first degree, sets him free. Second jury convicts, but not on the charge that he's brought up on, murder in the first degree, but manslaughter, accepting mitigation on Reed's part. You know, that there were circumstances that mitigated the crime. Darlington had charged the jury, and he made the case for conviction that led the jury to that verdict. And his case was that the state law, this anti-kidnapping law of 1820, could never have been intended to inflict the same penalty on a legitimate master reclaiming a slave as it would have on the kidnapper of a free man. That's the first part of his charge. And because the law could not cover the rendition of a slave, he said, the state act applied only to man stealing and not to a master reclaiming a runaway slave. All right? So the 1820 Act cannot apply in this case, which then makes you revert to the 1793 Fugitive Slave Act, which is federal law, which is so much more onerous. More importantly, this argument really meant, as far as Reed's self-defense was concerned, that he no longer had a right of self-defense, which removed the basis of his argument for an acquittal. Okay, so now we can go to the last slide. If you can find that, that would be helpful. Okay, so I made this little chart for you because Costas always makes charts, and, and I thought I should have one chart in all the 8 talks. We should have a chart. So we have a chart, finally. But I hope that this chart actually walks you a little less, with a little less difficulty through what I want to demonstrate. And the question here now, we're up to question 4. Remember, we only have 5 questions, so you're getting close to the end of the end. How and why did these 2 trials differ? Well, number 1, it was tried under state law, and Reed was perceived as a kidnap victim. The second trial basically was tried under the federal law, which made him fugitive. The first trial required 2 certificates, actually, the federal certificate and a state certificate of removal. In the second trial, there was no holding that any certificate was required, because in the 1793 Fugitive Slave Act, it said either a certificate or oral testimony, and so we don't need a written certificate. There was a sympathetic judge, number 3, in the first trial, and we have Darlington, the prosecutor of the first case, being the judge in the second, for that trial. As you can see, it's starting to add up, so that Reed's not going to get too much of a hearing here. Then we have number 4, the defense counsel, who did recuse himself, or was recused as county prosecutor, so that element of sympathy for Reed is eliminated. And in 5 and 6, just going over the second trial, you'll see there was a totally new defense team appointed. By the way, defense teams were appointed by the judge at his discretion. So I couldn't find any evidence to this effect, but there is a possibility that they would not approve those that have been recommended by the abolitionist contingent. By this point in trials, the PAS, Pennsylvania Abolition Society, was itself now a defendant, and it was being charged by slaveholders, so that under case law in Pennsylvania, the possibility that any slave fugitive who was aided by the PAS, Pennsylvania Abolition Society, should not get the benefit of their aid, because they themselves are committing a crime. So that predisposition in this case might have accounted for the appointing of a different, wholly different, all-new defense team. I can't demonstrate that for a fact, but there's some circumstantial evidence to that effect. But with regard to the prosecutors, not only did you have the chief prosecutor becoming judge, but you have a carryover of 2 of the other prosecutors. So there were 3 prosecutors in the first trial. So there's that on behalf of a conviction as well. Now we get to the witnesses, and here it's very clear that there's something going on. There had been a 2-to-1 differential under number 7 between the defense and the prosecution witnesses, 17 to 34. Go to number 8 under the first column. At the end of that trial, 88% of prosecution witnesses were paid a witness fee, but only 44% of defense witnesses, which means that as you go over to number 8 under the second column, the defense lost 8 critical witnesses that could have testified to the fact that he, that is to say, Reed, knew Griffith and recognized him, which would have made it murder rather than self-defense. That Reed returned to the scene to beat Shipley. One witness said he did, another one said he made no effort to do so. These witnesses would have contradicted evidence by a member of the slave catcher posse who escaped and was himself, by the way, now a fugitive from justice under Pennsylvania law. And it would have undermined the testimony of a second member of the posse, which would have undermined, or which would have made the case that the intent of the posse was felonious and illegal. So the witnesses that were lost were very important witnesses. They were critical witnesses. So he has to go into court absent those witnesses. Go to number 7 in the second column, and you'll see 11 to 37. Defense lost 6 witnesses from the first to the second trial. The prosecution added 3 witnesses from the first to the second trial. So now there's more of an imbalance, and now it's 3-to-1, the ratio, which is disadvantageous. So, in summary, you can see the differences. He's now no longer framed as a free man with a right to self-defense, etc., and importantly, to protection from search and seizure. But now he is framed as a fugitive, a slave, piece of property, and a murderer. Okay, so we can cut that down, and I'm going to now start to address the last questions here. Slide there, no. Okay, so what happened to Reed? He was not renditioned to the slave owner's family, but he did receive a 108-month sentence at hard labor, which adds up to 9 years. Outside the recommended sentencing for that manslaughter was 24 to 72 months. He got 108 months. This goes back to the Negro trials of 1705 to 1780, where they had stiffer penalties and different laws for blacks, right? It seems like there's some residual sense of that here. The actual sentence served, this is beyond the recommended sentencing for that conviction, would have been 41 months. He got 108 months. So you can see there's almost no way to argue this, that this was not disparate sentencing. This is disparate sentencing, and it's prejudicial in a lot of ways. It might simply be because of the scandalous nature of this trial, but also because of the presiding judge. As for the surviving members of the slave posse who escaped to Delaware in order to escape being charged under Pennsylvania law with, what would I say, 7 years hard labor, right? They were now themselves fugitives under the Fugitive Slave Clause in the Constitution, Article 4, which was the counterpart to fugitive slaves in that provision. They were fugitives for justice, but neither was indicted as a kidnapper, or indicted for a felony under the federal provisions, and both were used as witnesses. So that's unfortunate. Okay. So we are now up to the last piece. That takes care of the trial. And I want to sum up the series for you by making this case. I promised at the beginning of this long, I think I've kept you captive for 8 months, I think. What did I promise? Well, I said that we were going to examine themes that helped establish this new nation. I was going to demonstrate that law is a cultural phenomenon, and it's a foundation for the culture that bound the nation together. We were going to ask some fundamental questions. What is American society really like? What are its challenges to democracy based on looking at the early republic? And we were going to put society on trial, test its values, ask questions about land ownership, rebellion, libel, urban crime, military and civilian law, state law as opposed to federal law, Western expansion, popular grievances, republicanism and sedition, internal migration and equal treatment, the issues that split the nation. I don't know if you recollect, but you have been through all that. Whether you remember or not, I can barely remember myself. So we're going to see where we stand with regard to my conclusion on having treated those themes and having gone through that process. First of all, I want you to know that the questions about democracy are not new. Some people seem to think that the question of, is democracy going to fail in our time period? Are we somehow responsible for that? Are we culpable? Actually, democracy has been under threat in the scholarly literature since Richard Hofstadter's original article about the paranoid style in American politics in 1964. So this discussion has been going on for a long time. It was reinvigorated by Gordon Wood in 1982, and then issues were warned by Capocci and Kellerman in 2007, by Fukuyama and Diamond separately in 2015, and then the thread was really picked up and they ran with it with Levitsky and Ziblatt in 2018 and Mettler and Lieberman in 2019 and 2022. There's a long history of scholarship on this. So I don't want you to think that, this is something new that you all have to worry about. And in fact, we have the roots of it in the 1790s, big time, and in the early republic for sure, as I hope I have demonstrated to you. So what is my conclusion? I think democracy is under a threat of erasure. I think there is a threat to the very survival of democracy. Empires do fail, the Austro-Hungarian Empire, the Ottoman Empire, the Russian Empire. There is a risk of regime fragility. The early republic was a remarkable prototype for present-day conspiracy theories, riotous activity that purported to give the disenfranchised a right to govern or a voice in governance. I have concluded for myself that we have a long history of a paranoid style and conspiratorial style of politicking in this country, from the American Revolution and the Whiskey Rebellion right through to the Ku Klux Klan, to the McCarthy hearings, and to extremist conspiracy theories in our own time. So there is a trajectory with regard to democracy which is uneven, even Sisyphusian. If you regard the myth of Sisyphus, you're going to roll the rock up. No matter what we do, it's going to roll back down again. So I'm going to suggest that democracy may represent a terrible choice, as Churchill said, except for all the others. But it promises to make us stronger, as Nietzsche says. I would add, if we don't kill it first. So, with that, I am done. I have nothing left to say.
have the microphone, or I think it's on. Questions?
Here, right here.
I think I just sat through an historical account that would argue for critical race theory. Is that correct?
Wow. I mean, you and I belong to the news group, so you may recollect that I have a lot of issues with critical race theory. But there is a lot of historical evidence that there are problems.
Anyone else? Questions?
Nobody does. I'm always here.
And for that, we are grateful,
Well,
David.
a lot of things went through my mind as a student. A lot of things went through my mind there. Could you comment on the moral as opposed to legal thinking or self-interest thinking? To be clear here, as an economist, I think economists have too much sway in characterizing self-interest as the all-guiding issue more than moral judgment. When it comes to slavery, we tend to think morally. There's a good side and a bad side. But in the case of slavery in the North, I'm thinking of cheap labor in the North. Does that ever come up? How people in Pennsylvania might have stood to gain by having cheaper labor. It never even comes up, I think, but it should, because it's an interesting point. Are you aware of that? I know you didn't talk about that.
No, I haven't, but I will say that given slavery and the compromises we made in the Constitution with regard to it, there is this hypocrisy involved, because slavery not only enhanced white identity and gave a big lift to democracy with regard to those who would profit from it, whites, right? And in a way, it is a part of our founding, not only as an immoral function, the original sin, but also as that productive function with regard to the white side of the house and to democracy itself. Democracy wouldn't, I'm sorry to say this, but it would not be what it is if we hadn't had that horrible history behind it. It did produce some remarkable things, but it did so only for a very selective group of people. And that's a conclusion I would draw anyway.
I'll just make a related point,
Sure.
question. We've come to hear today all talk about job creators. Did slave owners ever make the case that they were job creators? Right? Because they were. They created jobs unwillingly. I'm just curious to think about that one, too. You have freed slaves coming north. I don't know what their working status was. I have no idea of how they were able to find ways to support themselves through work. But it's an interesting point. Today we embrace job creators as the good guys, the capitalists.
Yeah, well, the North did suffer greatly from having this huge labor pool of immigrants, fugitive slaves, emancipated slaves, who they could not serve. They could not employ them. And there was a rising, spectacular rise in crime rates for that reason. So if you think that that has any, is suggestive that slave owners were job creators, maybe that's a way to argue it. Okay? I think you should all go eat your dinner, because you have deserved it. Thank you for being with
early,
me,
yeah.
staying through this for so many months. Thanks, Richard. You've been a big help.
Question.
Question.
Oh, question.
What's next?
What's next? I'm going to go home and go to bed.
No, your uncle.
Oh, my uncle.
Next series.
Well, I will say that over Christmas I got my second book contract off of this, so I will be working on that until the end of the year. Oh, thank you for asking. Oh, next, after that. Okay, I'll ask Lily to set something up.